Let's dive deeper into Chapter 8 into trial courts and discuss preliminary stages of criminal cases. In this chapter, we'll discuss topics like crime and policing, arrests, defendants and prosecution, grand juries, exclusionary rules, case attrition, and the criminal justice wedding cake. Crimes known to the police increased for 20 years, but declined in the 1990s and have stabilized since. Data comes from the FBI Uniform Crime Reports. That data shows us that Type 1 offenses such as homicide, rape, arson, aggravated assaults, and the like are Type 1 offenses, and Type 2 offenses such as theft, simple assault, and public drunkenness. Table 8.1 shows us steps of criminal procedure. That is the procedure used in the course of a criminal trial. 1 in 4 crimes fall into the Type 1 category. Fighting crime is a regular campaign slogan by politicians, but it's really a difficult social problem to address. A large number of Americans are fearful of crime. However, studies show that is not necessarily related to the actual risks of crime. Table 8.1 here shows crimes that are known to police. You can see there has been a steady decrease and then a plateauing of crimes since the 1990s. Policing is a decentralized effort. Some 850,000 police officers work and serve our nearly 22,000 local agencies. Historically, policing has been connected to party politics. Today, it's regulated by a civil service. Table 8.2 shows us profiles of law enforcement in the United States. You can see in this table the number of agencies that exist at the state and county and local level, along with the number of full-time sworn officers. Of crimes brought to the attention of the police, only 20% result in an arrest. The defendant in most of these situations are charged with nonviolent offenses. Career criminals make up a disproportionate share of arrests, and felony defendants are most likely younger, male, and disproportionately members of minority groups. Table 8.2 shows us felony arrests in the millions, and you can see that the smallest grouping is in violent crimes, while the largest is in property, with a sizable number being drug-related crimes. The police must make an initial arrest before a judge and bring the arrested person before a judge without unnecessary delay, and that typically means within about 48 hours of the arrest. An initial appearance is a defendant's first encounter with the courts and the judicial process. In the initial appearance, a judge will advise defendants of the defendant's rights, and this initial appearance typically only lasts a few minutes. Table 8.3 gives us a profile of state prison inmates by various descriptions. You can see in this table that 81% of inmates have prior convictions. For major crimes, the judge in an initial appearance will set bail, schedule next court appearance, and appoint a special counsel or a public defender if the defendant is an indigent. Bail is a guarantee that in return for being released from jail, the accused will return to court as needed. Procedures vary depending on the seriousness of a crime. For minor offenses, bail may be posted at the police station. For felony or serious misdemeanors, the court must set a bond amount. Once amount is set, there are 4 ways to post a bond. Bond procedures include providing cash bonds, providing property bonds, using a bail bondsman, which posts the bond for the defendant and charges a non-refundable fee, or personal recognizance, where a judge may release defendant from jail without monetary bail. The poor often wait in jail, while the rich are able to post bonds. In serious cases, there is a lot of discretion in setting the bail amount. Over 700,000 people are held in jail versus prison at any given time. Debate is what is the goal of bail, and the debate revolves around ensuring the appearance of the defendant versus protecting the public. Preventative detention emphasizes the public protection aspect and allows judges to hold over those accused of dangerous crimes without bail. The prosecution is found at all major governmental levels, national or federal, state, county, and local. They may be called U.S. attorneys or state attorneys general or prosecutors or district attorneys and so on. Prosecutors have broad discretion. Prosecutors decide which cases to pursue or to prosecute. The Sixth Amendment to the United States Constitution requires the defendant to be given information about the charges that are filed against them. A charging document includes the name of the person charged, a brief description of how and where the offense was committed, and the statute allegedly violated. Three major types of charging documents exist. One is a complaint. It's supported by an oath or an affirmation of an arresting officer and used in misdemeanor or city ordinance violations. Another type of charging document is information. It's identical to the complaint but signed by the prosecutor. And lastly is an indictment. It's issued by a grand jury of citizens. There's considerable discretion in the prosecutor's decision to follow an arrest with a charge. The prosecutor controls the doors to the courthouse. There's very little oversight of the prosecutor's filing charges, other than prosecutors are typically elected officials. Some police consider every decision not to charge as a repudiation of their policing. A preliminary hearing is the first time a criminal case is reviewed by someone other than a law enforcement official. An arrested person is entitled to a timely hearing before a neutral judge to determine probable cause for the detention. A preliminary hearing protects the innocent and provides the defendant with an overview of the case against him, and it does not require the establishment of guilt, only that of probable cause. Grand juries are different from trial juries in that they determine probable cause. Grand juries have two primary functions. First, to determine whether there is probable cause the defendant committed the crime, and to protect the public from overzealous prosecutors. Grand juries issue a true bill if the case continues with an indictment. Grand jury uses various means, but is used mostly for felonies and capital crimes. Grand jury size can vary from anywhere from 6 jurors to 23. Normally, these jurors are selected in a manner similar to trial juries. They are impaneled for a set time and they meet periodically. And the legal protections of criminal court do not apply to grand juries. The work is done in secret. A plurality of the vote is necessary, and there's no right to an attorney. Prosecutors dominate the grand jury process. Here's Table 8.4, which shows grand jury requirements by state. Exclusionary rules are many factors that affect how the police arrest and prosecutors charge those accused of committing crimes. The Bill of Rights, for instance, and Supreme Court decisions affect that process in great detail, and the exclusionary rule prohibits the prosecutor from using illegally obtained evidence during a trial. Exclusionary rules there are three distinct exclusionary rules. First, identification of suspects. Second, confessions. Third, searches. Identification of suspects is where defendants have the right to be assisted by counsel during a police lineup. Confessions mean no physical or psychological coercion, that Miranda rights must be read, and that legal guarantees must be made. Searches relate to the gathering of physical evidence, and it must follow certain rules and be truthful and relevant. Lawyers ask for evidence to be excluded through pretrial motions. Debate centers on whether convictions lost and the guilty let go because of suppressed evidence. It's difficult to resolve the debate because it's hard to determine precisely why cases are dropped or defendants are let go or found not guilty. Let's talk for a moment about case attrition. The exercise of discretion by the police or the prosecutor or a judge causes many cases to be dropped. Out of 100 felony arrests, only 55 survive to a trial stage. Once a case reaches felony court, it's highly likely to end in a guilty plea or a trial verdict of guilty. There are variations across courts in case attrition rates. Table 8.3 shows case attrition of felony arrests in 28 urban prosecutors' offices. You can see how they vary. Why do case attrition occur? Well, legal judgments. At every stage, a decision is made about whether there is sufficient legal evidence to move a case forward. Attrition also occurs because of policy priorities. Prosecutors are simply not interested in pursuing some certain cases, yet very aggressively pursue others. Attrition also occurs because of substantive assessment. Some cases are dropped because the officials decide prosecution would serve no useful purpose. Let's think for a minute about this funny thing called a criminal justice wedding cake. Not all cases should be treated or counted the same. Samuel Walker suggests using a wedding cake as a metaphor, with each layer representing a different type of case, but with consistency in each layer. Walker observes that criminal justice officials handle the various layers of the cake very differently. Table 8.4 shows us the criminal justice wedding cake. Layer 4 is the misdemeanors, Layer 3, the lesser felonies, Layer 2, the serious felonies, with Layer 1 being the celebrated high-profile cases. Celebrated cases at the top of the wedding cake dominate the news headlines, but are atypical of most cases. The judicial process is carefully followed in these cases, and these cases are likely to go to a full jury trial, and they have considerable impact on public perception, perhaps even too much impact on public perception. Serious and lesser felonies are the second and third layers of the cake. Differentiation between the two levels is based on the seriousness of the crime, the criminal record of the suspect, and the relationship between the victim and the offender. Serious felonies are carefully handled, and lesser felonies tend to be dispensed of routinely and quickly. Misdemeanors far outnumber all other types of cases and make the bottom layer of the cake. Half of all misdemeanor cases represent simply public order offenses. Fewer than a third represent any sort of crime against a person or property. Misdemeanors are processed very differently from felonies. They're routinely handled, defendants are arraigned en masse, guilt is rarely contested, and punishment is not severe. In conclusion, America's courts process millions of criminal cases every year. Most are simply routine. Very few are high profile. Crime rates continue to be high profile, yet a frequent subject of political campaigns. Yet crime is persistent even if dropping, despite considerable effort and expenditures. Discretions occur at every stage of the criminal justice process, whether it be by the court or by the prosecutor or for some other reason.